A landmark ruling from a sharply divided U.S. Supreme Court, clearing the way for same-sex marriage in all 50 states. Welcome to the Kelly File, everyone. I'm Megyn Kelly. Tonight, a remarkable sight at the White House, which is aglow in the colors of the rainbow, celebrating what the administration calls a new chapter in the history of American civil rights. Critics say 5 unelected and unaccountable judges have overstepped their authority by assuming the power to create new fundamental rights and compelling the country to redefine the institution of marriage. Others say this is a seminal moment in the civil rights movement of our time. It came down in a 5-4 decision, which split the court so sharply that Chief Justice John Roberts read his dissent from the bench for the first time ever.
Well, Megyn, in a 5-4 opinion, the Supreme Court did not hold back, declaring that same-sex marriage is now the law of the land in all 50 states. Justice Kennedy, writing for the majority, said this, quote, "The plaintiffs respect marriage so deeply that they seek to find its fulfillment for themselves," adding, "They ask for equal dignity in the eyes of the law. The Constitution grants them that right."
This decision affirms what millions of Americans already believe in their hearts. When all Americans are treated as equal, we are all more free.
Each of the 4 dissenting justices wrote his own opinion, including the Chief Justice John Roberts, who characterized the opinion this way, quote, "The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent." He went on to ask, just who do we think we are? Supporters of traditional marriage have long voiced concerns about what happens to them now, especially those who have sincere religious convictions about the issue of marriage. Justice Kennedy addressed that, saying this, "The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths, and to their own deep aspirations to continue the family structure they have long revered." But nearly all the dissenting justices seemed unconvinced, warning that cases like the ones we've seen involving Christian florists, photographers, and bakers who declined to take part in same-sex ceremonies and were punished as a result will continue. In his dissent, Justice Alito said, quote, "I assume that those who cling to old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they will risk being labeled as bigots and treated as such by governments, employers, and schools." It seems now almost certain that one of those religious liberty cases is likely to land on the court's docket within the next year or so. Megyn.
Shannon Bream, thank you so much. And joining me now with reaction, Governor Mike Huckabee, presidential candidate in 2016. Governor, thank you so much for being here. Your reaction to the decision by the U.S. Supreme Court today.
Well, I kind of shudder when I hear people say that it is now the law of the land, because I think all of us who passed high school civics knows that the Supreme Court can't make a law. Congress can, has to be signed, executed by the president. The Supreme Court can review a law. They can decide what they believe the law says. But the Congress has to actually create a law. What they did was not rule on marriage equality. What they did was redefine marriage. And there's a fundamental difference. Their decision was a political decision. It was not a legal one. And they had to reach out into thin air to create a right that simply is not listed in the Constitution. And I think that's what's so significant about the dissenting views that you see from the 4 justices. What this really means, and I think Roberts puts it well, 5 unelected black-robe lawyers essentially bypassed the legislative process, the political process that is fundamental to our country, and just made a decision that they had no authority or power to make.
But on the subject of reading rights into the Constitution that you say don't exist, the supporters of the majority opinion would say, isn't that what they did in Brown versus Board of Education, that they interpreted the Equal Protection Clause to provide these rights, even though it's not explicit. You have to look in modern day America at what was written and try to understand what the founders meant. And this court in 2015 says the same way they interpreted that clause to provide equal rights for African Americans so many years ago, they've interpreted it this way for gays and lesbians today.
Well, I think it's a fundamental difference. I mean, for several hundred years, they've had the opportunity to say that marriage was really misdefined, and they should have always had this opportunity. Even previous Supreme Court cases that dealt with marriage or dealt with homosexuality never assumed that there was a civil right of a person to redefine the very institution of marriage. And Megyn, again, This is not just about a sameness of love. This is something far greater than that, far more encompassing that. This is redefining a fundamental institution and doing it in a record period of time. I mean, this has happened very quickly.
Well, but let me ask
and
you this,
while there are a
Governor.
lot of people celebrating, okay.
I know that you put out a campaign release today saying, I will not acquiesce to an imperial court, and said, we must resist and reject judicial tyranny, not retreat. I mean, what does that mean? You have to accept this ruling, right? I mean, are you planning on not accepting the ruling in a way?
Well, how do we accept something that is on its face unconstitutional?
Well,
I mean, has the Congress yet acted?
How do you not
Have
accept
they yet
it? It's
said
the Supreme
that this
Court's
is...
job to interpret the Constitution and tell us what it means. And like it or not, they do get the final say unless the people decide to pass a constitutional amendment.
Glad you brought that up. That's the whole point. The people do have a right to say. And in over 30 states, they did say. And they said very clearly that they wanted to affirm the laws of nature and the laws of nature's God, words from the Declaration of Independence, and keep marriage what it's always been. When we say that the Supreme Court has the last word, they had the last word in Dred Scott in 1857, declaring that black people were property, that black people weren't fully human. I know of no one that believes that that was a proper decision, or that we still should abide by it today, or that Abraham Lincoln should have just rolled over, put up the white flag of surrender and said, hey, that's the law of the land. There's nothing I could do about it. Thank God he didn't think that Dred Scott was okay.
Let me ask you before I let you go, because they're showing it on the board now as you and I are discussing this case. Your thoughts, your reaction to the White House aglow in rainbow colors tonight?
Well, again, this is a president who has pushed this agenda, but I remind Americans that this president believed, like I did back in 2008, or at least he claimed to, when he said that marriage was between a man and a woman. And here's what he said. He said that he believed that because as a Christian, God was in the mix. Now, one of three things happened. Either he was lying then, he's lying now, or God changed the definition of marriage between 2008 and 2012, and Barack Obama was the only one who got the new version.
Joining us to explain what the ruling means and what it does not, Jonathan Turley, constitutional attorney and professor at the George Washington University Law School. Great to see you again tonight, Professor. So here's the first question. Does it mean, and by the way, it was the 4 liberals plus Justice Kennedy against the conservatives on the court, the 4 liberals and Kennedy won. So does this mean that churches are now going to have to perform same-sex weddings?
Well, that's part of the next chapter that has to be written. You know, part of the decision, which I thought was a bit interesting, is that Justice Kennedy didn't base this decision on the status of same-sex couples as homosexuals, but rather on this sort of right to dignity. He's mentioned this in a series of cases now, and that's what unleashed a lot of the criticism from his colleagues, saying, well, where is this right of dignity and intimacy that you're referring to? And that right's going to have to be defined a little more for us to know what happens when it comes into conflict with rights of free speech or free exercise. So you're saying it's possible?
You're saying it's possible we could see legitimate cases, or cases that aren't thrown out instantly, against the clergy or the Catholic Church, somebody, for refusing to perform a same-sex wedding?
No, I don't think that the clergy is really in any threat. I think the right of free exercise is going to be protected. Where you're going to see this conflict is more on the edges. Many of these religious institutions, particularly the Catholic Church, has an assortment of different types of services. And we've already seen conflicts on the edges on delivering those services, but then discriminating in the view of these couples in terms of their receipt of certain services.
So, for example, a Catholic university that allows married housing for heterosexual couples, but not for gays and lesbians who are married.
I think that's where you're going to see it, on the edges. And then you're going to see a very interesting conflict over things like bakeries and photographers. So far, the courts have been ruling against them and saying that they can be fined, they can be sanctioned for failing to offer their services to same-sex couples. And part of the confusion that's going to come out of this opinion is, once again, this somewhat ambiguous right. Since it wasn't focused on their status, they didn't create a protected class around homosexuals as a group, that's going to make this a little more challenging as to know what gives when you have these types of conflicts.
And what about what about Justice Alito's comment that Shannon Bream was commenting on, that now, I want to find it here, but now that all those who believe that same-sex marriage is not okay, people who oppose it, believe in traditional marriage, will be run the risk of being treated as bigots by the government now. Is that where we are?
Well, I hope that's not where we are, and I don't expect it will be. This court remains very strong in its support for free speech. I'm hoping that'll remain. I was concerned today in the coverage, and I tried to make this point repeatedly, that the suggestion that these justices in dissent are bigots, or people that take this view are bigots, is really wrong-headed. I mean, you can actually support same-sex marriage and still believe that the Supreme Court should not play this role.